Live with us, and thanks for staying on. As I mentioned before the break, Embattled Judge Nana Makhubele is not giving up without a fight. The judge, who is facing impeachment after being found guilty of gross misconduct, is taking her fight to the Pretoria High Court to review and set aside the Judicial Conduct Tribunal's decision. She is also challenging the parliamentary process that could possibly lead to her impeachment. For more on this, I'm joined now by Judge's Matter Researcher and Advocacy Officer, Mbekezeli Benjamin. Mbekezeli, good to have you. Thank you very much for coming on. Firstly, Makhubele was found guilty by the Judicial Conduct Tribunal, and the ruling was then endorsed by the Judicial Service Commission. Talk to us about those two processes and what possibly they could have looked at to reach this conclusion.
Good afternoon, Mr. Mhlili, and good afternoon to the viewers at home. Well, the Judicial Conduct Tribunal and the Judicial Service Commission are two different bodies. The one, you could think of it as the child of the other. So the tribunal is the child of the JSC, and the work of the tribunal is obviously to find the facts when there's a complaint against a judge. The tribunal is the one that hears the witnesses and hears the testimony, including the cross-examination, and then ultimately produces a report. The report says, these are the factual findings that we found. This is what they mean in terms of guilty or not guilty of misconduct. And this is then submitted to the Judicial Service Commission. And the Judicial Service Commission is the one that takes the final decision on whether or not a judge is guilty of gross misconduct. And it's the JC is essentially the one that initiates the impeachment processes for judges. And so in this case, the Judicial Conduct Tribunal had found Judge Makhubele guilty of gross misconduct on one of the grounds. They had found her guilty of lesser form of misconduct on a second ground. But when it got to the Judicial Service Commission, they said both grounds constitute gross misconduct, and for that, she should be impeached, and they sent it to Parliament.
What are the facts at hand?
So the facts are pretty simple. Judge Makhubele is accused of two grounds of misconduct. The first one is that she held two positions at the same time. One position was that she was a judge of the High Court, and the other one was that she was the chairperson of the board of PRASA, the rail agency. And those two positions are incompatible, and in fact, the law prohibits you from being a judge and something else. You can only ever be a judge. And so the first ground was that she violated the law by holding two positions at the same time. And then the second ground was that while she was at PRASA, she got involved in the legal affairs of PRASA in a way that prejudiced the company, in a way that assisted a company that was accused of state capture-related corruption, and that she helped in getting a settlement done that was worth about 56 million rand. And so the Judicial Service Commission said that this constituted misconduct in the fact that there was dishonesty in her involvement, and she was not entitled to be involved in that way in the legal affairs of PRASA. So the JC looked at both grounds, and they said, both for holding two positions at the same time and for your involvement at PRASA, you are guilty of gross misconduct and you should be removed from office through the process of impeachment.
Now, consistently in both processes, I mean, and I hope maybe I'm correct in assuming that this is the same defense that she would be taking to the Pretoria High Court. What has been her defense?
Yes, so her defense is on two grounds. The first one is that at the time that she was the chairperson of PRASA, she was not a judge. See, she says that, yes, President Jacob Zuma signed an appointment certificate for her in November of 2017, saying that she must start work on the 1st of January 2018. But President Ramaphosa signed a second appointment certificate in April, saying that she now starts in June of 2018. And between those two presidents signing her appointment certificate, she resigned from PRASA. And so she says that at the time at which she became a judge officially through the signature of President Ramaphosa, she was no longer involved at PRASA. And so the JSC could not investigate her conduct, but secondly, she wasn't a judge, so it wasn't a violation of the law. And then secondly, she says that even if she did anything wrong at PRASA, the JSC is not the correct body to investigate that kind of conduct, and so they shouldn't even have considered it. And so she says that on both grounds, the JSC was not supposed to investigate her alleged misconduct, and that she was not supposed to then be found guilty and now be subject to an impeachment process. She also lists 13 other grounds. So it's not only what the JSC did, but there are 13 other grounds that she lists in the court papers. And essentially what she says is that this whole process should not have taken place, and she should not be under impeachment at the moment.
Do you see this process going the way of Judge Mutata, maybe Judge John Klope, in terms of time and the length and the processes and the various courts that it's going to go through, even before Parliament can actually begin its work in terms of impeachment?
Well, look, Parliament has already said that they are starting with the impeachment process. Last week, Parliament, the Justice Committee of Parliament initiated what is a six-step process in Parliament. So when Parliament is doing an impeachment, they follow 6 steps, and already they've done 2 of the 6. And so that means the train is already moving when it comes to Parliament. And the basis for doing so is that they say that the judge, even though she is saying that she should not be impeached and she has filed a court application, but Parliament is acting in terms of the Constitution. They say that in terms of Section 177, they have no choice. Once the JSC makes a finding, they have no choice but to initiate the impeachment process. And also, Section 237 of the Constitution gives them an obligation for them to proceed unless there is an interdict. And so they are saying that, well, Parliament is saying that unless the judge gets an interdict to stop Parliament from going ahead with the impeachment process, they are going to go ahead. So they are not going to wait around until there is a court judgment on these issues. They will go ahead with the impeachment process. And so I think tactically, the judge made a mistake here. She should have gotten the interdict and then did a review of the other issues. She did not do the interdict, and so she is now vulnerable in the sense that Parliament is already moving ahead with or without the court process.
What is the Pretoria High Court then to determine? I mean, having had the Judicial Conduct Tribunal and the Judicial Service Commission doing the investigation as far as this matter is concerned?
So the High Court is doing a very different job, right? Because the judge is reviewing what the tribunal and what the Judicial Service Commission did. So what the court is essentially looking at is, are these what the tribunal, what the JSC has done, do they meet the constitutional standards? Was it rational? Was it proper? Was it lawful? So it's a more narrow job than actually finding out whether the judge did something wrong or whether the judge violated the law. They're simply looking at whether the JSC itself, in doing this job, did they follow the law? Did they follow proper procedure? Did they give her a hearing? For example, one of the complaints that the judge is making in her court application is that at crucial points during this investigation process, she was not given legal representation. And she said that because she was not given legal representation, that prejudiced her rights. And so this is one of the grounds that the court will have to assess whether is it a lawful basis to set aside the findings of the tribunal and of the Judicial Service Commission.
Yeah. It seems, though, Mbekezeli, I mean, I'm reading here this report that the matter actually does involve the Speaker of Parliament. The Speaker saying, well, she will not oppose the Gauteng High Court Judge Nana Makhubele's urgent application to hold Parliament's consideration of the recommendation that she be impeached.
So yes, the Speaker is one of the respondents in the judge's court application. And the Speaker is quite correct to say that she will not oppose it. So she filed what is called a notice to abide, which means that she will go with what the court decides at the end of the day. But one thing that the Speaker does raise is this question of what are the constitutional obligations that are sitting on Parliament right now? And as I explained earlier, Section 177 and Section 237 of the Constitution obliges or puts an obligation or a duty on Parliament to initiate the impeachment process once the JSC has made a finding, unless there is an interdict. And so in this case, the Speaker is essentially saying that I don't have an interdict that stops me from going ahead with the work that I'm supposed to do in terms of the Constitution. And unless I get that interdict, I will go ahead. But the court will decide what it decides, but I will not oppose it, or I will not file any court papers to sort of interrupt the court processes. The court processes can go ahead, but the parliamentary processes at the same time will go ahead on their own side as well.
If Parliament impeaches Judge Makhubele and then later the courts find the impeachment was, or at least the decision of the JSC incorrect, what are the implications of that for the president and even for Parliament itself?
Well, I don't see a huge number of implications, in the sense that if the court finds that the impeachment should not have taken place, then the court will issue that, and the Parliament will essentially reverse the impeachment process by Parliament. On the judge herself, the only time that her salary, for example, stops is only when the president signs the resolution. So Parliament must take a resolution to say by 2/3 majority, we are removing the judge from office. They send it to the president. The president will then determine the exact date when the judge stops being a judge, and he will sign that. And from that date onwards, the judge will not get a salary. But if the court process goes ahead and actually interrupts this before the president signs off, then I don't see any prejudice to the judge or to anyone implicated in this. But the main thing, I think, is that Parliament has indicated that they will go ahead with the impeachment process. Already we know that this complaint was filed in 2019, actually. It's 7 years old already. And so that's why Parliament was saying that we will go ahead regardless. If the court does come to a different finding, they will simply have to unscramble the egg, and I don't think that it's impossible. It's not straightforward, but it's not impossible.
Mbekezeli Benjamin, appreciate your time. Judges Matter Research and Advocacy Officer there.